May your lordship, I beg to mention item number 26, your lordship. 26, I have been appointed as LLC for the victim complainant, and I have already received a paper book also. So this matter may be listed day after tomorrow, your lordship. And my name may be reflected in the cause list. Twenty-six. I'm representing the victim, your lordship, as LLC. Lordship, then this matter will be listed on Monday, your lordship. Monday 7th.
7 and 8. So lots of cases are already been fixed, I think so.
Sorry, Lordship.
Already lots of cases are already been fixed.
Then can it be day after tomorrow?
Huh?
Day after tomorrow, Friday?
Right.
Then after a week.
Okay, then fix it on Monday.
Because the Pilan is in jail, Lordship.
Obliged.
7, 8.
May I please? I would like to mention item number 21. This is listed in order section.
Yes.
Kindly it will be taken up tomorrow. I mean, listed
Tomorrow?
tomorrow.
What?
It's in order section.
Yes, then
21. Kindly it may be taken up tomorrow and it may be listed in admission section.
otherwise the service is completed.
Yes, it's a joint petition. Joint petition.
No, it is an order column.
Yes. It's listed in the order column.
Tomorrow can it be? But this is so and so, and counseling, petition, and also had MSL Hageti Land Petition PP, appearing on behalf of state respondent. Case the service is completed in a sense. It's a joint petition.
This is a joint.
Service is already completed. Lindsay matter accordingly. Tomorrow is which date tomorrow? Third. Huh? Third. Is the matter on 3rd of August, is already in the admission column.
Elsa is supposed to call.
No, it's not in joint.
So I don't know, he is saying that it is a joint petition.
NCN में joint petition है trial में नहीं पहुंचा. हाँ है.
Or FIR is there, Lordship. If the FIR is there, Lordship, then CD may be called for Lordship.
CD last time call कर दिया.
CDS
It's been called last time only. This is the.
already called,
Yes.
but it seems that it has not been received yet.
Then okay, Lordship, again we ask for CD, Lordship. If it's a call and.
So then it should not be fixed on tomorrow. Also call for the LCA, is the matter on so and so, and we don't list it on 3rd. List the matter on the next week. Tenth. Call for this can copy for there is no any stay order. FIR is investigation is still under progress.
There is a stay.
Stay was there. Stay for proceeding or stay for
the-
case has already been charged.
Investigate further.
Investigation
of
Lordship,
the-
because this is Elsa is not there, Lordship, because.
No, so it's.
No, I'm not on LCR. This stay is there was investigation was stay.
Lordship.
Acha.
Let's say Lordship, CD may be called for Lordship. Or last occasion we call for the CD.
If you already said, then don't need to call for the scan copy. CD can be called. CD can be called. Okay. Nice. Under which section cases?
This is 376. Obliged.
My lord, I beg to mention item number 18. My lord, the service report is still await on regard of respondent number 2 and 3. my lord.
Case has not been reached now. Heard you, Mr.
Taggu.
Mr. So and counsel for the petition. Submitted that the service is still awaited for respond number 2 and 3. Let the matter be accordingly listed after 3 weeks.
My lord, interim order may be continued.
Procuring the interim order, now you are insisting for awaiting service, na? Interim be continued. Please.
Much obliged.
Item number 13. Yes. What you have submitted?
With the consent of the other party, this matter will be
After 4 weeks. The consent of the other party, the matter will be settled.
and not sit was interim there may be continued.
Interim to thank you. Interim be continued. Please. One and one 12 is one RFA. Yes, and one is CRP. Both the matters are connected or what? No.
This the matter of the trees.
Why you need adjournment? Why you need adjournment?
Oh, Lordship, here leading counsel is under treatment.
Who is he?
His leg is fractured.
Who is he?
K. Malolan.
K?
K. Malolan.
Acha, K. Acha, he is in this post condition. Same order books in the morning. So you are appealing for the other side?
Yes, I'm for the revision petition.
Revision petition. Acha. With 1 and 12, same order will be held due to in disposition condition of Mr. K. Matter may be listed after 4 weeks.
Please.
List after 4 weeks.
Lordship,
Please.
Lordship, it is item number 21, we just now, it has been taken adjournment, Lordship. Here,
Yes.
Lordship, item number 21, Lordship, LCR has been called for, sorry, CD was called for, but there was no stay order.
Stay order was not.
Not there, I am just looking this order, last order. Lordship.
Oh, acha. Anyway, okay then. That is scan copy.
No, Lordship, call for the scan copy then, Lordship, because there's no stay orders there.
There.
Yes.
Also
Like-
the scan.
May I please, Your Lordship? I beg to mention item number 7 here, sir. On behalf of M.A. Laskar. AB, Your Honor. The
He's
learned
not
counsel, conducting counsel, Mr. A. Laskar, is
Ah.
out of station, ma'am. He is in Delhi. Therefore, it may be taken up after 2 weeks.
On behalf of students, which is submitted, he is out of station, with the matter will sit. You are appealing?
Yes, yes, Your Lordship.
Also have listed. The learned petition PP appealing.
People.
Otherwise, we have received the scan copy of the LCR also.
Yes, that may be reflected, Your Lordship, in the order.
Scan copy of the LCR has already been received.
Obliged.
Lordship, may I place for adjournment item number 10 and 11?
Hmm.
And
You are in order call.
I'm from petitioner side and my senior counsel Devasis Day is on medical leave. And even though Lordship,
Who is he?
there is no opposite counsel, in last hearing, they withdraw the wakalatnama. So may I prayer for
No,
give,
you are praying for adjournment, no, that will be the only.
yes,
Who is your senior?
Devasis Day.
Devashish Day. He is not,
Lordship.
he is not keeping well. He is out of station or he is not keeping
He is on medical leave.
medical? So and so is medical. leave.
So I prayer for at least 4 weeks of.
List after 4.
Madam. Lordship, I beg to mention item number 19.
19.
Yes, ma'am. My lord, I have taken a consent from opposite party also, my lord. My lord, service report in respect to respondent number 2 is still awaited. So matter may be taken up after 4 weeks. ma'am.
With the consent of the student, so the learned counsel put a petition for an adjournment and we submitted that the service report on respond number 2 is still awaited. Let the matter be accordingly listed after 4 weeks.
My lord, here I'm mentioning item number 22 also, my lord, on behalf of Mr. D. Pangal.
On behalf of
D. Pangal.
Deepan,
Yes,
he
my
is
lord.
not available today.
Yes.
On behalf of so and so, let the matter be listed after 2 weeks. It will be listed after 2 weeks. For why he is absent?
My lord, he's out of station, my lord.
Out of station. So it will be after 2 weeks. In the case of 2018 matters.
All right.
Lordship, I beg to mention item number 23 and 25 or 24 on behalf
23
of,
and 24.
yes, Lordship, on behalf of D. Pangin. Consent
Same.
have been taken, matter may be listed after 4 weeks.
Now see, these two matters are also of 2018 matters. So 4 weeks we are not allowing, we are allowing 3 weeks, otherwise you complete it.
Okay.
Because it is a 3 week, 18 matters. List after 3 weeks.
Obliged.
May I? Your Lordship, I beg to mention item number 5 and 6. My senior could not make it due to some personal difficulties.
Who is the senior?
Mukpatin, sir. Your Lordship, kindly adjourn this matter for 4 weeks.
Ground, we mentioned the ground for Mukpatin, he is paid by judgment. And with the consent of the other side, this is a matter of 4 weeks. Okay.
Deeply obliged.
4 weeks.
Lordship, I would like to mention item number 3. Because one eye has to be filed before taking up this matter. It may be fixed on
Your eye is infected.
the
why?
one, I have to file one eye. Not
You
reply
have to
to,
file one eye.
Yeah, to-
Your one eye is infected. In fact, your both eyes are infected.
tomorrow I am going to file eye interlocutory application. It may be taken up day after tomorrow.
Your good name PS. What? So good name was your?
El Kabong,
Mr. L. Kadun, the learned counsel for this issue. And accordingly, he submitted that some more time is required as he is going to file an I in connection with this case. Accordingly, this is a matter after how many weeks you need?
you are the day after tomorrow. Yeah.
After one. Next after 1 week, yes.
Obliged.
May I, Your Lordship? Your Lordship, I would like to mention item number 25. Your Honor, the conducting counsel is out of station on medical ground, Your Honor.
Mr. Deepangi,
B. Jamo.
you are on 25.
Yes, Your Lordship.
So Mr. Pangi also absent. right?
Yes, Your Lordship, but this case is, Your Lordship, pursued by B. Jamo, Your Lordship.
Oh, अच्छा. V. Jamo.
Yes.
The matter may be listed up to 3 weeks, Your Lordship.
So and so, he is out of station.
Yes, Your Lordship.
Column also call for the list after 4 weeks.
Much obliged.
My lord, I beg to mention item number 2.
The transfer petition, right?
Yes. The leading counsel is engaged in, is not here.
Who is leading counsel? Titi Dara.
No, Mr. T. Kamchi.
Huh?
Mr. T. Kamchi.
আচ্ছা আচ্ছা ঠিক আছে। So it is a transfer matter only.
Yes.
Is there any issues? You are not in a position to say, I think she.
My lord, I have not laid my hands today in this brief. My younger was handling this. The transfer and posting.
It will be admitted and after.
Yes, correct.
Do you, I mean, LCR is not required in this case?
No.
Yes, verbal submission will do. LCR is most probably
No,
not.
no,
required.
not
It's simply a
required. I
draft.
think it seems to be not required.
Oh.
Lord.
Much obliged.
Seven. Yes, 27.
May I submit, my lord?
Yes.
Lord, here I am challenging, my lord, two things, my lord. One, my lord, SARS, my lord, SARS sheet pertaining to me, my lord. The date is 15 to 10, 18, my lord, pending before JMFC, my lord, Pangin, my lord. Second, my lord, I am also challenging the, my lord, SARS order dated 25/8/2022, my lord. Now, two things I'm challenging. Now, before coming to this case, my how this case arises, my lord, I'll invite kind attention of my lord at page number background of the case, my lord. My lord, kindly turn to page number 97, my lord.
97.
97, my lord. Nine seven, my lord. And next one, number 8.
Yes.
This is, my lord, we'll see, my lord, this is WPC number 668/2017, my lord. Name of the petitioner is Daniel Eco, my lord. My lord, you kindly note, this is important, my lord, Daniel Eco, my lord. Now, here, my lord, counsel for the FLN, my lord, will see, my lord, 1, 2, 3, 4, 5, 6 number, my lord, T. Pavan, my lord. My lord, noted, my lord, after white tie, my lord, T. Pavan, my lord. T. Pavan, my lord. He is one of the youngest counsel in this case, my lord.
T.
Pavan, my lord.
T. Parlin.
Pavin, Pabin, Pavin, my lord. T. Pavin, my lord. My lord, you kindly note this, my lord. T. Pavin, my lord. Fifth number, my lord. Fifth number. T. Pavin, my lord. T. Pavin, my lord. At page number 99, my lord, will kindly note, my lord. 99. Now 99, 99. Respondent number 2 is, my lord, Deputy Commissioner Siang District Pangin, my lord. Siang District Pangin. This is the complainant in the FIR, my lord, where I have been suspected, my lord. That's why, my lord, I'm indicating this, my lord. Respondent 2, my lord. Now, next page, my lord, 100, my lord, 100, my lord. This is, my lord, will kindly note the date of the interim order, my lord. This is interim order passed in that 18/9/2017. 18/9/2017, my lord. The reason for, my lord, I'm para 1, 2, 3, 4, 5. I'm reading, my lord. That would be relevant. Para 5 would be relevant, my lord. Reason for it. It is stated that the leak paper where viral on social media, and to that extent, the photograph of leaked paper has been annexed to the writ petition. My lord, will kindly wrote, my lord, leaked paper, question papers annexed in the writ petition, my lord. The said photograph of question paper showed that a question paper is lying in the bomb floor, which could not have been possible venue of exam in question, which was in fact stated to have been conducted in government higher secondary school Bowling and Pang in Siang district, my lord. Now taking this, my lord, at page number 101, my lord, interim order was passed, my lord, staying the whole selection process, my lord. Now at annexation number 9, my lord, is the annexation number 9, my lord. 9, my lord, is the final order in the desk case. My lord, will kindly look at 103, my lord, page number 103, my lord. 103, my lord. 103, my lord. 103 again, my lord. 103. At name of the petitioner council, my lord. Say 1, 2, 3, 4, 5, 8. Fifth number, my lord. T. Pavin, my lord. T. Pavin, my lord. This is the present petitioner in this case, my lord. T. Pavin, my lord. He is the engaged counsel. He was engaged counsel in this case, my lord. Now, ultimately, my lord, a final order was passed, my lord, on my lord, in this case, my lord, on 15 to 2018, my lord, interfering whole selection process, my lord. Selection process were interfered, my lord, was interfered, my lord. Selection process was interfered by the dishonorable.
It was stayed.
Is in interim order, my lord, earlier interim, that was
It
stayed.
was stayed, and then what is the?
Interfere, my lord.
Interfere.
Interfere, my lord. Now thereafter, my lord, they, my lord, my lord will kindly see at page number 10, my lord. Oh, sorry, my lord. Sorry, in 114, my lord. Annex number 10, my lord. Some of the aggrieved party, my lord, appeal against the judgment, my lord, passed by a single bench, my lord. That is the read appeal number 2018, my lord. Appeal, my lord. But this read appeal was also dismissed, my lord. Dismissed in the sense, my lord, judgment in the single bench was upheld, my lord. Now at page number 122, my lord. 122, my lord. Page number 122, my lord. Page number 2. Annex number 11, my lord. Single bench judgment was upheld by the division bench, my lord. Against that, they also went for special leave appeal, my lord. Now that was dismissed, my lord. At page 122, my lord, down below, my lord, last. I'm reading, my lord. We do not find any ground to entertain this petition, especially petition is dismissed accordingly, my lord. This was dismissed, my lord. Now I'm indicating all those peg of the case, my lord, to impress upon my lord that, my lord, this Mr. The T. Pavin, my lord, the present petitioner, my present petitioner, engaged counsel, my lord, in this whole case, my lord, the engaged counsel, my lord. Now he was given some documents, my lord, by the petitioner, my lord. My lord has seen the name of the petitioner, my lord, that is Daniel Iko, my lord. He has given him some documents, my lord. According to this document was used in, my lord, this before filing WPC, my lord, before this on court, my lord. My lord, kindly recall the interim order. Interim order was passed on, my lord, 18/9/2017, my lord. My lord, kindly recall that 18/9/2017 interim order was passed by this honorable court, my lord. I'm indicating to satisfy my lord that once, my lord, this honorable court has passed interim order, my lord. Now all those documents, my lord, become a public documents, my lord. This is all those documents were before this honorable court, my lord. Now that become a public documents, my lord. Now, my lord, at page number, my lord, 38, my lord. This FIR was lost, my lord. 38, my lord. My lord. This is, my lord, kindly, this is 6/10/2017, my lord. After 1 month of the passing of interim order by this honorable court, my lord. My lord will kindly note the date. It's 6/10/2017, my lord. That is after lapse of 1 month of the interim order passed by this honorable court, my lord. The FIR, my lord, contain its say, my lord, sir, it has been observed that certain allegation has been made regarding the conduct of UDC, LDC, MTS equivalent forces under the establishment of DC Siang district. Pangin by claiming that the question paper of UDC was leaked and certain photograph has been uploaded in social media forum. Whereas there has not been a single person as evidence who had access to question paper before the exam, and hence the matter of leakage of question papers seem ill-founded. Whereas the exam of the post of UDC was conducted at 2 examination centers, Pangin and Bowling Government Higher Secondary School, wherein there has been an instance where some dishonest invigilator examiner could have sneak out the examination center with a question paper answer sheet for her self-interest after completion of the said written examination, and might have taken photograph of the same in view of defaming the district administration. It is also pertaining to mention that it is also pertaining to mention in one series, this is the petitioner, present petition, my lord. Advocate has uploaded a picture of boy said to hold the question paper of written exam for the post of UDC in his Facebook profile and close, my lord. Also, as per the petition filed by the petitioner Sri Sasensa at Guwahati High Court Permanent Petition of 669-2017, it is pertaining to mention that one of the allegations made in that question paper was leaked, and he was found carrying a photograph of the said question paper, and hence may give some information to this matter. In this regard, the officer in charge police station Pangin is requested to lodge FIR under 193-420 of IPC against unknown person and conduct inquiry and undertake the fact and reality of claim question paper and initiate necessary law process as deemed fit and proper. Now on this, my lord, this is down below is a complaint in my lord Rahul Singh, IS Deputy Commissioner Siang District, my lord. The respondent in number 2 in the writ petition, my lord. Now on the basis of this, my lord, investigation was carried out, my lord. My lord, we kindly find charge sheet at page number 'That body of the charge sheet start from page number 67, my lord. 67, starting. This is the body of the charge sheet, my lord. 67, my lord. May I read, my lord? The prosecution history case in brief on 6/10/2017, a written FIR was received from Sri Sasensa Siang, DC Siang, that one unknown person have made allegation that the question paper for the post of UDC conduct at 2 exam centers with Sasensa were leaked as a certain photograph has been uploaded in social media forum. On receipt of above FIR, that Pangin PS case number 23/2007 under section 420 193 IPC registered, and I have investigated into the case. During the investigation, both exam center, government Higher Secondary Polling and government Higher Secondary Pangin had visited, and 79 invigilator and exam assistant superintendent and superintendent were examined and recorded their statement. They stated that during the examination there was no leakage of question paper sheet from their respective exam center on 19/8/2017. The informant also examined and recorded his statement. In course of investigation, one Sri Sasensa, my lord, posted at Bowling, Sri Sasensa, Pasigat, who had arrested on 10/4/2018 on interrogation. Srimati Sasensa admitted that she was deployed as an invigilator at UDC Center in Government Higher Secondary Pangin on 19/8/2017. And she took one question paper after the written examination as was over with her consent of authority and kept it in her house for future reference of her child. On the same day, Sri Sasensa took it from her house and without her consent subsequently, and Sri Sasensa received the stolen question paper from Sri Sasensa, and he took photograph with his child, and later Sri Sasensa, this Sasensa, Daniel Eco, was the petitioner in the WPC model, took out the photograph of the question paper stolen through the mobile Bluetooth with the consent of Sasensa. During investigation, a prayer made to the Honorable Court executive magistrate belonging to record a confidential statement under 160 above LS accused person. Accordingly, same has been recorded. The arrested accused person released on bail from the court. On 5/5/2018, co-accused, and this is the present petition, my lord. Son of Sasan, practicing advocate of Itanagar Permanent Bench of Guwahati High Court, appear at PS along with AB 64 number dated 2/5/2008, obtained from Itanagar Bench of Guwahati High Court. Accordingly, he has been arrested on 5/5/2018 and released on bail after recording his stand. On interrogation, he admitted he received some image of the question paper from Sri Sasan Sas, and without help of where he got, he uploaded the same in social media. On dated LS Sasan Sas appeared along along with obtained from Itanagar Bench. That would be now charge sheet, my lord. Accordingly, my lord.
No, advocate is the petitioner here.
Yes, my lord, advocate petition. Now, at page number 68, my lord, I'm skipping other part, my lord. Last 4 para I'm reading, my lord. See, later Sri Sasan advocate received his stolen question paper with image from Sri Sasan and Abin is also under section 114 134. Found will start talking about that is the allegation, my lord. Now, based on this, my lord, yes, I am challenging the search order dated also, my lord. That at page number 90, my lord. Page number 90. Annex on 6.
Page number.
90, my lord. Annex number 690. This is the search order I am challenging, my lord. The relevant part, my lord, would be, my lord, at page number. Page number 492, my lord. 92, my lord. 92. Second last para I'm reading, my lord. Second last, my lord. 92. Upon hearing all the learned counsel on the point of search and up then pursued the CR, prima facie it appeared that there was a material to go for trial against Sri such and such under section 381 IPC against such and such under 380 IPC against such and such 411 against accused the 411 and against present petition that is taken under 411, my lord. Now, separate search was 94, my lord. Page number 94, my lord. 94, my lord. Page number 94, my lord. The search, head of the search, my lord, against me, my lord. Firstly, my lord, you have received a stolen question paper from sir, who is stolen from the house by Simi and you have received a question paper knowingly or having known to believe that such property is stolen and you have thereby committed offense. Now, I'm putting question myself. Suppose tomorrow, my lord, if my lord, this is my lord, I as a counsel, my lord, as if someone supposed to come to me, whether I need to question the my client, my lord, from where you got that material, my lord. Now that will be have a serious consequence, my lord, to the as a court officer also, my lord. How, my lord, that would be possible that, my lord, every advocate, my lord, will, my lord, inquiry about the authenticity and from where, my lord, that documents is collect, my lord. Now I'm even assuming, my lord, as my lord, this is under my application is under 482, my lord. I would not be in position to test the merit of this case. Now I am putting myself a question, my lord. If this assuming this whole statement are correct, my lord, whether this opens under 411 will be made out, my lord. Now 411, my lord, will kind of 400 start with dishonest, my lord. 411.
He was holding the paper.
Pardon, my lord.
Why he was holding the question paper? Your petitioner.
Petitioner not holding the question paper, my lord.
That it was recovered from his position.
No, my lord. What their allegation is that, my lord, present petitioner, my lord, upload a photo, my lord, with one person holding a question paper, my lord. Upload, my lord. Now I already indicate, my lord, the order, my lord, interim order has passed on September, my lord. Now, this FIR is after 1 my lord. Once that become my lord, suppose tomorrow I'm putting question myself. Now. Tomorrow, suppose my lord court pass a order, my lord. If I obtained that, suppose some order condition or CTC, my lord. If I suppose upload that, my lord, in the social media, my lord, whether that will be open, my lord. That is the issue in this case, my lord. Ultimately, this FIR was lost after lapse of 1 month, my lord, alleging my name in the FIR, my lord. Now, during the investigation, it was found that yes, my lord, I have uploaded some photo in the Facebook, my lord. Now, whether that will become under the open under 411, my lord. Now, 411, my lord, will kindly have a look at 411, my lord. What the 411 say, my lord?
Receiving.
In IPC, my lord.
Yes.
Kindly. Sorry, my lord. But dishonestly receiving a stolen property, my lord. Now, on the record, my lord will satisfy my lord. This on the record, Mr. Daniel Iko was the petitioner, my lord. This is matter of record of this court, my lord. Now, I was the counsel, my lord. He approached, my lord. He approached me, my lord. I filed a writ petition, my lord. It's not the case that I received a document, I kept it myself, my lord. I used that in the court of law, my lord. Now he's my client. Till Supreme Court, my lord, he was my client, my lord. That so that, my lord, he was my client, my lord. And till till the apex court, my lord, he was my client. In such a situation, my lord, where is the question of that? I received that stolen property, my lord, dishonestly and retain any stolen, my lord. I did not never that retain. I used that while discharging my professional duty as an advocate, my lord. I filed that before this honorable court, my lord. Now, this is dishonest receiving of stolen property. Whoever dishonestly receive or retain any stolen property, my lord, knowing or having reason to believe that same would be stolen property, my lord, would be now, if this is to attract me, my lord, tomorrow, my lord, all the advocate, my lord, need to inquiry, my lord, about any documents supplied by his client, my lord, where from he got that, my lord. I find, my lord, he is whole this prosecution, my lord, is in somewhere, my lord, indirectly interfering into the administration of justice, my lord, and professional duty of the advocate, my lord. If this person is to be allowed, my lord, how it be possible, my lord? Every advocate, my lord, will ask the source, my lord, from where, my lord, any client, my lord, his client or her client got the document. Now, my lord, I have read out the source also, my lord. I'm normally, my lord, law, my lord, appreciate, my lord, law is settled, my lord. The presiding officer, my lord, cannot be a merely a post office, my lord. He need to apply his own mind, my lord. Now, if my lord, this SARS claim against me, my lord, only on the pleading, my lord, of the PP, my lord, this SARS has been framed, my lord. How this 411, my lord, on the basis of the SARS, my lord, at least that's some reason, my lord. Yes, my lord, this is the pay, my lord, this would apply against him, my lord. Only on the submission of the PP, my lord, we'll see again the SARS, my lord. But what the learned court recorded, my lord. Learned court recorded the region, my lord, it is page number 92, my lord. 92, my lord. On the other hand, this is PP, my lord. APPP submitted as part of SARS submit IO of the case. And if we go to the stand witness, it appeared that the SARS is found to well established against accusation. He had taken the question paper without knowledge and consent to hire authority. The party that opened under 380 is also found to be well established against the accused Sir on the with regard to other remaining 3 accused, namely Sri Sir, he submitted open are found well established against the 3 accused as all or 3 has received the stolen paper in any. Now, only a receiving the 411 say, my lord, it should be if I receive a stolen property dishonestly, my lord, then only 411 be attracted. How simply receiving of stolen property, my lord, with a dishonest intention, my lord, cannot be open under 411, my lord. Now, I find, my lord, similar situation, I find very relevant observation by the Madras High Court in this case, my lord. I'm reading the para 9, my lord. Relevant para I have indicated paras 5, 7, 11, 12, 15, 16, my lord. The petitioner, para 5, my lord, is a practicing advocate in court at Dindiguli, and he is the counsel on the record for the accused such and such, etc. The case of prosecution is that on 25. Now here also, it is recorded, my lord. It is the counsel on record, my lord. In my case also, my lord, I am the counsel on record before this honorable court, my lord. In the writ petition, not only the apex court also, my lord. Now at para 7, my lord.
Petition was filed.
Pardon,
Petition was filed for under which circumstances?
Pardon, my lord.
Petition was filed. Why petition was filed?
Writ petition is filed to set aside the, my lord, whole selection process, my lord. A selection process was conducted under the chairmanship of this complainant, my lord.
There in the writ petition, he produced the photographs.
Yes, my lord. I have all that is that and in the interim order I have indicated, my lord. My lord. Now 7, my lord, I am reading, it is pertaining to note that the main charge level against the present accused is set around section 457, my lord. Now, most relevant in this part, my lord, will kindly at page number para 11, my lord. Para 11. Advocate, in addition to being professional, are also officer of the court and play a vital role in administration of justice. The legal profession cannot be equated with any other traditional profession. It is not commercial in nature, and it is a novel profession considering the nature of the duty to perform and its impact on the society. The advocate are supposed to be fearless and independent in the protection of right of litigation. It is their duty to free their client access strenuously to the best of their ability, and an advocate must no doubt give his very best to every cause that he plead for his client. The nature of work of the advocate is not only limited to court, and they are expected to visit the property or dispute a series of occurrence to have a. Now at para 15, my lord. As rightly contended by the learned counsel for the petitioner, a new trend has been immersed in the implicating the advocate as a accused para 15, madam. 15, para 15, madam. As rightly contended by the learned counsel of petitioner, a new trend has been emerging in implicating advocate as an accused along with their client with ulterior motive of achieving the intended result quickly or immediately. The practice of implicating advocate along with their client for the offense alleged to have been committed by client is to be condemned, and such practice is to be depressed. Now, even, my lord, whole prosecution story, my lord, is to be believed, my lord. The prosecution say, my lord, from Srimati Sas and Sas, that was given to other 2 persons, my lord. From 2 persons, my client, my lord, obtained that, my lord. That is their case, my lord. Prosecution, my client somewhere without their knowledge from Bluetooth, using Bluetooth of the mobile, my lord, obtained it, my lord. Now, undisputed date was given to me, my lord. Stolen property. That was given to me, my lord, for what purpose, my lord? The answer to that question, my lord, is on the record, my lord. On the record, that was given to me for filing writ petition, my lord. Now, that is matter of record, my lord. Now, my lord, can you address, my lord, for what purpose that was given to me, my lord? If I suppose receive that property, my lord, and I do retain that, my lord, there may be a case, my lord. Here is a case, my lord. I am an advocate, and on the record, my lord, that was given to me, my lord. On that was used in the court of law, my lord, in the writ petition, my lord. Now, after lapse of 1 month, my lord, this the respondent number 2, my lord, under whose chairmanship, my lord, the exam was held, my lord. He lost a FIR, my lord. Now, I would say, my lord, there is no more vindictive, my lord, case than this, my lord. He was a party, my lord. He, after 1 month, my lord, it not the case before 1 month, my lord. If after I used that a public document, my lord, I produced that as a court of law while discharging my professional duty, my lord. On the basis of that, my lord, they have lost allegation. My decision, my lord, my humble submission, my next date of the case is fixed on 7 of this 8 of this month, my lord. I pray that, my lord, proceeding, my lord, or not whole proceeding is maybe stay, my lord. Yes, my lord, even my suppose, my lord, assuming, my lord, all this prosecuting history, my lord, is believed, my lord. Surely, my lord, 411, my lord, would not be a thing, my lord. 400 for the purpose of past ingredients, my lord, is dishonestly, my lord. Now there is no in the source of my lord is in the head of the source also, my lord. There is
Okay, you want to argue it on 7th?
no, my lord. Next date of this trial court, my lord. Is this is case of trial of the case, my lord. Is
Yes, yes, now you want to argue it another day also. Why are you arguing for so long?
oh, this is most my lord. If my lord,
Yes.
Yes, your lordship, with fierce, all your lordship, I would like to make a fair submission, your lordship.
Motion says his only prayer is to consider that whether it can be stayed further.
Yes, your lordship.
That much.
Yes,
And any other submission?
your lordship, if your lordship is limited to the interim prayer, your lordship, since there is a, in my humble understanding, I have gone through the provision also and the record also, which in earlier occasion also I reiterate before the court that whether the prima facie case is made out on that has to be looked into. The first part of this 411 completed, that the stolen property is there. This is an alleged in connection with the other accused. This alleged accused person, the name my learned brother has already been specified. But so far as the second part, knowingly keeping the stolen property, that will constitute the offense of 411. Here, your lordship, I have gone through the material also, the statement of the alleged accused, present applicant, and the accused from which the stolen property has been received. I have gone through the statement. If your lordship allow me to read it, then I will read it, your lordship. Then in that case, the second part doesn't complete, your lordship. Second part regarding whether that person has a knowledge or not. So far as the 161 statement is concerned, no doubt he has admitted that the photographs were given to him. The counsel for the accused is given to him, but he don't have the regarding the knowledge whether it was stolen or what was not there. It come into picture only after the filing of the FIR, the allegation. So, your lordship, so far as interim, your lordship, the stay praying is concerned, your lordship. For the other accused, your lordship, this court may not interfere, your lordship, because against them there is material is there. But so far as the present applicant is concerned, only in respect of this applicant, your lordship, the further proceeding may be stayed. Is your lordship thinking? Yeah.
Administrator, and for me, the Learned Counsel for the petition also administrated the Learned additional PP appearing on the state respondent. And this is an application under section so and so against the charge sheet and the order dated so and so framing of charge against the present petition. Is submitted by the Learned Counsel for the petition that the present petitioner is no way connected in the alleged offense and the mere reading of the FIR as well as the other connected documents, it is very much evident that 411 is not attracted against the present petitioner. Though the charge is framed against him without considering the entire aspects of the case. Further, is submitted that as the accused against the petitioner is facing the trial, let the further proceeding may be stayed until further order. According to page for interim prayer to stay the further proceeding in respect of the present petition. The learned additional people, Mr. E. has submitted that he has already produced the record and the 161 statements of the accused and the other two accused persons. However, he raised no objection in regards to if there is any interim order regarding the stay of the further proceeding in case number so and so. only in respect of the present petition. Considering the submission made by the learned counsel for the both sides, I hereby, I hereby state the further proceeding in case number, which the case number is GR 268,
My lord, case number, my lord,
GR 268,
Here case number
GR case number 268.
268. Your Lordship.
2018 under section 381, 380, 411 IPC arising out of PNG, the Pangian Police Station, case number 23, 2017 under section 381, 380, 411 IPC dated 6/10/2022 only in respect of the present petition. However, the case will proceed further in respect of the other co-accused. As a scan copy of the LCR be called for accordingly. Let the matter be listed. Do we now listed for
Your Lordship.
hearing only?
Yes, Your Lord. Yeah, notice has to be issued, Your Lordship, to
Oh,
respond
is
number
it
2, Your
been
Lordship, not
Yes.
issued, yes, yes.
So and so. Notice be issued to respond number 2. However, there is no formal notice is required to issue for the respond number 1 as the learned edition PP has already appeared on behalf of state respond number 1. Accordingly, matter be listed.
Orders, Your Lordship.
Be listed after. He is a police officer, no?
IS officer. Your Lordship.
IS officer, my lord.
And whatever, IS officer. That's it.
Deputy Commissioner,
So
Your
now his present place of posting.
My lord, no, sir, that's why I have made his, this, my lord.
It will come out, they just make an inquiry, the present place
Yes.
of posting only you send.
Yes, ma'am.
Otherwise it will come.
Post, instead of posting, well, I have directly mentioned his head of the department, my
The
lord.
present place of posting of the respond number. In this accordingly after 4 days.
High level.
LCR, scan copy of
Yes,
LCR, yes, Your
scan
Lordship.
copy of the LCR
Yes.
report.
Your Lord, the proceeding in respect of the other accused
Yes,
will
we
be,
continue.
okay, Your Lordship, deeply obliged.
High level.
4 weeks. Obliged. Your Lordship. On last occasion, Lordship, CD was called.
Oh, yes.
The PPTP analysis, that is important. Classification, in fact, that analysis was helpful along with this.
Is there any,
Objection, your lordship, with regard to the status report, your lordship, we see on the first page, your lordship.
yes,
The last paragraph, your lordship, reason for the remand, your lordship, we see that there are still some witnesses which has been identified, your lordship, through CCTV, your lordship. Those witnesses are also to be examined, your lordship. Your lordship will see that through the entire incident, your lordship, all of these two accused along with the deceased, all were together, your lordship. It's when they try to get out of the bar, your lordship, that's when they found that their friend was lying there in a pool of blood, your lordship. Now, your lordship will also see the photographs, your lordship. It's at page number 33, your lordship. Your Lordship will see, observe the injuries, Your Lordship. Now, the fingerprints of all the accused has also been sent, Your Lordship. Those are also, those fingers, the result of those fingerprints are also in a. Now, the investigation is also at a very early stage, Your Lordship will see, and therefore.
Any other subject on this?
Yes, Lordship. Since the arrest of alleged accused person, today is the 26th day. The alleged accused person are in the custody, yes. And since from the very beginning, as I have stated earlier occasion also, the alleged accused person, they have voluntarily went to the police station to inform about the incident before the OC of the police station Pasighat. So the alleged accused person are very much concerned about the incident, and they are cooperating with the investigation as to how to find out the exact reason behind the incident. So there is no question that the alleged accused person would not cooperate with the investigation on later stage also, since the alleged accused person are the friend of the victim deceased for last 7-8 years, and they have been living like a brothers of same parents from last 7 years. So in this stage, the alleged accused person may be enlarged on bail, and the applicant being the brother-in-law of the present alleged accused person.
Brother-in-law,
Yes, the applicant in this bail application.
brother-in-law.
Yes, and he has control over the alleged accused person, and moreover, the parents of alleged accused person are at the age of 80 years, 80 plus, and they are staying at Silapatra, Assam. And the alleged accused person is staying there at Alo, West Siang district, and he used to visit frequently in every week to look after their the aging parents. So the alleged accused person may be enlarged on that, and rest I would rest upon my learned colleagues.
Lordship, is submitted by my learned friend. We have been arrested on the basis of suspicion and speculation.
You are also behind the bar list since.
Same date, we were arrested on 7/7/2023, Lordship. Since then, we are behind the bar, Lordship. Now, Lordship, if we see the FIR also, Lordship, it's very clear that we have been named in the FIR. In fact, we are named in the FIR. Lordship, may kindly come to page 16, Lordship, Annex 2 series, Lordship, of my bail application, 69 of 2023. Bail application 29. 69. Lordship.
69.
69. I'm on 69, Lordship. Bail application number 69. Item number 9. Item number 9, Lordship. Item 9. Yes.
You're in para or page?
I'm on page 16, Lordship, Annex 2 series, Lordship. This is the written FIR lodged by the father of the deceased. Here the alleged accused is Toli Lolen, Lordship. Now, as submitted by my learned friend, I was the one, Lordship. May kindly come. I'll be reading the first line, Lordship. It is to inform you that on so and so that at around 6:47 AM, my wife got information from one Sri Luhit Daye that one Sri Toli Lolen, I'm the alleged accused. I'm representing him. Told him through mobile phone that my son, namely Minli Taka, who is the deceased, is about 17 years, dead with multiple head injuries near Beer Bar, Pane, Baskota, Pasighat at early morning on so and so. Now, I was the one who has informed the relative of the victim, Lordship, deceased, about the incident, Lordship. Now, where is the motive, Lordship? Now, as submitted by my learned friend, Lordship. They were together, Lordship. For the last 1 month, they were together, traveling around Arunachal Pradesh, sailing lottery. And on that unfaithful day, Lordship, they were having some drinks after a long, tiresome journey. They were together in the bar, Lordship, till 4:30, Lordship. One of the friend, he went back to the hotel where they were staying. Since he was tired, he went back. And the rest of the 3 friends, they were together, Lordship. Now suddenly at the early morning stage, 4:30, around 4:30, just when they wanted to walk out from the bar, they were looking for their friends. Lordship. Since he was missing, when downstairs, informed by the hotel owners that one person is injured, he's in the downstairs. They rushed to the downstairs, found that their friends were injured. He was still breathing. So they have taken to the hospital and rest accordingly informed to the relatives. Even they have lodged one FIR, but then the police authority they did not register their FIR, but they have taken up the registered by the relatives of the deceased. Lordship, may kindly come to the second page, Lordship, where the contention that we are raising in this case regarding suspicion and speculation will become very clear, Lordship. I am reading the second para, last line, Lordship. I am very much doubt that the above name, Sri Deepak Hajirika, who is in the item number 8, Lordship, Sri Tolilon, who is in item number 9, Lordship, is the alleged accused, and Sri Marjum Bagra might have killed my son. So this is just on the basis of suspicion, Lordship. Merely on being suspicion, Lordship, it's been arrested. And then we have moved on bail application before the district and session judge, Lordship. There we have raised the same ground, saying that we are innocent and merely on the basis of suspicion and speculation, we were arrested. Now, initially, our bail was rejected, Lordship. Lordship, may kindly just come to page 31 of my bail application. Page 31, Annexure 5. This is the bail order, rejected bail order by district and session judge, Lordship. Page 31. Now here, on the basis of the CD submitted by the IO, now what the IO has contended, Lordship, in his investigation, Lordship. The IO stated that the accused person and the deceased had consumed alcohol in the comic bar and a family restaurant together in presence of the people, to which IO needs to be examined the witnesses. It is also stated by the IO that PME report is not yet received by the IO of the case, and custodial interrogation of the accused persons are required to compare with the result of CCTV footage and CDR reports. Now, regarding CDR, we are not disputing that on the unfaithful day, we are not together. We are there together. It's not being disputed. Now, regarding CCTV footage, if the CCTV footage analysis is there, it becomes very clear that whether we are involved in murdering the as alleged by the prosecution side, Lord, whether we are really involved in the incident, Lord. Now, on this basis, our bail was rejected. Now, the subsequent bail application was filed. Lordship, I have annexed the subsequent bail application also, page 32 to 35. Now, the subsequent bail was rejected. However, one point that has to be noted here is, Lordship, page 43, Lordship. While rejecting the subsequent bail application, now the IO has clearly stated before the learned court below, saying that our custodial interrogation is no more required. May commonly come to page 43. Second paragraph. I'm reading second paragraph. IO of the case has submitted the status report, but it has not revealed any completion of the investigation. But it has, this is important, but it has reported that the accused is not required for custodial interrogation. The IO contending that custodial interrogation is no more required, there must be some reason behind saying that custodial interrogation is no more required. Maybe he has gone through the CCTV footage, maybe he has analyzed the CDR, maybe he has seen the PME report, post-mortem report. On that basis, he might have contended that no more custodial interrogation is required. But then the observation made by the learned court below, saying that whether the investigation is completed or not, whether there is a separate ground for any successive bail application, on that mere ground, our bail was rejected. In spite of the report being submitted by the IO, clearly contending that the custodial interrogation is no more required. That may be noted, Lordship. And then here in this case, Lordship will clearly see that whether in such cases, of course, it's a heinous crime, Lordship. Since the allegation is of a murder, Lordship, it's of course a heinous crime. But we should not fail to see that whether the arrested person is put behind the bar merely on the basis of suspicion and speculation. Lordship may kindly see and go through the records whether there is a prima facie case against us. We say that we are not at all involved in this case. We are innocent, Lordship. Now CCTV analysis would be there, Lordship, which would clearly speak whether we are involved in the incident. Maybe he has fallen down from the building. Maybe that might have been the cause of his death, Lordship. There must be a cause of death, Lordship, at least. By now, Lordship, investigating agency might have figured out or find out. It's been 26 days, Lordship. So it's almost 1 month, Lordship. They might have come up with some certain story or certain facts, the cause of his death, Lordship. Now, on the basis saying that some more witnesses has to be examined. Now, what has to be seen here is, Lordship, whether the alleged accused, they are really involved in this case, whether against us there is a prima facie case, Lordship. That has to be seen, Lordship. Since it's a heinous offense and the allegation is gravity of the offense is high, therefore, what has to be seen is gravity of the prima facie case is established against us. We say that it's merely on the basis of suspicion. Since we were the last person seen with the alleged, Lordship, disease, so why we are arrested, Lordship? Or Lordship will see that there is no, even if we presume, not accepting, Lordship, the motive is not at all there, Lordship. What would have been the motive to murder one of the colleague or one of my friend, Lordship, who were having drinks and enjoying together that night, Lordship? Lordship will see that there is no motive at all, Lordship. So Lordship will kindly see that this alleged accused, in my case, he is a government servant, Lordship. Government servant working as PTI, Lordship, in SSA, Lordship.
He's a government servant.
Government servant, Lordship.
Who you're
I have
accused.
accused, Lordship.
So how he is dealing with such lottery and all?
Lordship,
What lottery?
maybe he was helping the friends for
Yes,
selling the
he-
lotteries,
he
Lordship.
is also engaging in this lottery business.
Lordship,
So
he's
in
not,
other way also he is guilty of other offenses. Being a government servant, how can he be involved?
Lordship, he was not directly involved, but he might have been assisting them, Lordship.
If I may, your lordship. As per their submission being made, your lordship, the lordship will see that the mother was not present, the informant was not present at that point of time, your lordship. Whosoever has given the information, your lordship, they have clearly given the information that these 3 persons were together till the disease was found. The disease conditions were found, your lordship.
Not disputing, Lordship. We are not disputing
Let
that
me-
fact.
Then they have taken them to taken the disease to the medical, and thereafter they have surrendered before the police. Now your lordship will see that FIR is not an encyclopedia. This information whatsoever was given to the informant, your lordship will see that on suspicion, why? Last seen together, your lordship will see. Secondly, your lordship will see that as per their submission that they are relatives, they have been together, friends together for 10 years. The other is an uncle. Why did they not directly inform the mother, your lordship? They had to inform through another friends, your lordship. Your lordship will also see that the FIR was received at 13 hours, it is, and the information got at around 6:47 AM, your lordship. The entire incident took at around 4:30. Lordship will see. Prior to that, they have taken the deceased to the medical, your lordship. At that point of time also, they could have called their mother, your lordship. The nearest, the uncle, whatsoever submission is being given, your lordship, and directly could have. Now, another thing your lordship will see, where is any proviso wherein it is said that once an IO says that a person's custodial interrogation is not necessary, and subsequently on finding certain evidences, submit before the court that their custodial interrogation is necessary. Where is any proviso saying that once the IO said that his integration is not necessary, subsequently he has to be given bail on that account on subsequent request made to the court that his custodial interrogation is necessary. Now, they have admitted to the fact that on the first occasion, the CDR, the PME report, the CCTV footage, the ground for rejection was on that ground. Now, on the second bail application, your lordship will see the IO stated that their interrogation was not necessary, and the order is of dated 21/7/2023. The recent CD submitted before your lordship is on 30/7/2023. Within this span of 10 days, your lordship, they have come out with certain evidences, your lordship, which they need to verify. Your lordship has clearly seen that no one is a witness as per the statement. So to make a case, your lordship, 60 days period to file a charge sheet, your lordship, they are still investigating. First of all, fingerprints is also required to be taken, which has been given for examination, which is awaited, your lordship. In such a situation, the investigations are on full swing, trying to find out that what is the cause, your lordship. Now they are from Alo, they have come to Pasighat, and unfortunately this kind of incident has happened, your lordship. Now if they are released on bail, your lordship, the investigation officer had to call them on several occasions to come to different districts for investigation, your lordship. The only reason for suspecting them, your lordship, the investigation is entirely based on, normally investigation starts from suspicion, your lordship. That is how the investigation go through and try to find the exact cause of the death, your lordship.
To bring more clarity on the fact, lordship, I have made this submit. Lordship, initially in the FIR, there were 3 persons, at least to have committed offense. But one of the alleged accused person, Sri Marjum Bagra, has been released by the investigation under 169 CRPC. And lordship, I am not disputing the submission made by the learned PP, but as far as the investigation is concerned, to put behind person bar is to investigate and to unearth the fact of the case. But here in the case, the alleged accused person is ready to cooperate with the investigation. Since the alleged accused person is presently residing at Alo, which is just 2 hours driving distance from Alo to Pasighat. And now the alleged accused person and the applicant itself is ready to present before the IO, present before the investigation officer, any point of time, as and when called by the alleged accused, the IO. As the alleged accused person, he himself want to know the actual cause of death of his friend. He was like his own brother. And moreover, the alleged accused person could not contact the parent directly in the morning hour because he was at police station to inform the police personnel about the incident, and he has instructed and asked his friend, one of the alleged accused person, the applicant in item number 9, to inform the family and relatives whosoever about the incident. So the alleged accused person is very much innocent and very much concerned about the incident also. So he may be released on the bail, and he is ready to cooperate with all the terms and conditions laid down upon him by this honorable court. With strictest terms and conditions, he may be released on bail. This is my humble prayer and humble submission before this honorable.
Just to clarify, your lordship, with regard to Marjum Bagra, your lordship, he was granted bail on the very first occasion. Why? Because though all of them were sitting together, your lordship, he had left the place at 10 PM to the hotel to sleep, your lordship. So he was not there till the last moment of 4:30 when the incident happened between the, with the accused, Your Lordship. Therefore, the only for the reason for him to get bail was that he had already went to his hotel at around 10 PM. Your Lordship. That was the reason he was given bail.
Lordship, may kindly see whether, as I have already submitted, whether there is a prima facie case against us. That's all, Lordship, as per the record, Lordship. If not, Lordship, I'll humbly pray that we may be enlarged on bail, Lordship.
The law order, I'm going to counsel. Detail in the verdict.
Did-
This. How many meters are left now? No? 45 meters. Hearings are already been adjourned. So one was, we were searching you only, so that matter will take up. Okay. What? Not filed by, you are for respondent? or-
So,
my lord, I need some more time
to file, yes.
You are for the petitioner.
Yes. Yes, Lord.
Artist students, so the learned counsel for the petition, so how you're good then?
T Lampu.
Magistrate T. Lampu,
Better maybe release after 3 weeks. After 3 weeks.
appear on behalf of the respondent, submitted that some more time is required for filing the affidavit in opposition, they are allowed. But other respondents, the service is completed for the other respondent,
The Lordship, sole respondent, Lordship.
sole respondent.
Sole respondent.
Some more time for again, right, prayer allowed, with the matter be listed. You want 3 weeks?
Yes.
3 weeks you need to require,
Yes.
right? 3 weeks.
Well, Lordship, this is interim, Lordship.
Interim was there.
Interim
be
is-
continued, previous. Interim be continued. Yes, item number 4.
May it please, Lordship. Lordship, this is a joint petition filed by the victim, the informant father, and the alleged accused. Lordship, here it is due to the misunderstanding, an FIR was lodged by the victim's father, and that is so petitioner number 3. He lodged an FIR against 3 accused, 2 were juveniles, and they are not before this honorable court, and only 1 accused, that petitioner number 1. Listen. Lordship will find FIR at page 14. May bless. To the officer in charge police station Rupa dated 28 January 2020, subject FIR. Sir, I have honored to inform you that sir, on 27/1/2020 at around 9 PM, I got a telephonic information from my sister that my stepdaughter, namely so and so, has been forcefully taken by one Sri Tenjing Sojan and his friend from Rupa and confined somewhere at Bomdila area. I, along with my friend, went to Bomdila search for my daughter. On searching, I came to know that my daughter was confined somewhere at Forest Colony. I went there, heard my daughter crying. I went to the house and found one boy was there with my daughter who used force on my daughter. I rescued her, taken the boy to the police station for complaint. Later, I came to know my daughter, there were 3 boys in 2 motorcycles and they lifted her from Rupa Market. Therefore, I request Your Honor may take appropriate action against the culprit under provisions of law. Now, the informant is there 27 years of age. The informant father is the what's it, the stepfather.
Informant is
this-
27 years
Yes, then his
and
stepfather.
she is the stepdaughter.
Yes, his stepdaughter.
Achha.
Now, after filing is, after the investigation was done and it was charge sheeted. Now trial is going on. Now, lordship here, actually this affair was due to the misunderstanding. Both the victim and the accused, they were in relationship, but they could not tell the parents. So they went there to the inside
It is submitted by him that from the appeal memo, it seems that there is a delay of
263 days.
263 days in preferring the appeal. However, there is no statement made in the memo of appeal in that regard. So the LSC may be accordingly directed to incorporate regarding the delay in lodging the FIR. If any. Let the matter be accordingly listed after, it's a jail appeal, na?
Yes, your lordship.
After 2 weeks.
2 weeks. Your lordship. Obliged, your lordship. May I plead your lordship? Your lordship, this is a joint petition, your honor. Filed for quashing of GR number 818 to 2016. Here, your honor, the petition number 1 is the wife and petition number 2 is the husband. Your honor, charged under section 498A and 323 of IPC.
Charge has already been framed or charge sheeted?
Already charged with it, your honor.
Charge sheeted and now charge is also framed or not?
No, no, the matter is in the court below, fixed for CC.
Fixed for CC.
Yes, your,
Yes, so this is the joint petition.
yes, your lordship.
Is there any other compromise agreement?
Yes, Lord, your worship, in page number 34, annexure for your honor, there is a settlement agreement between the parties. May I read your worship? That both the party, operating party, that both the party have settled their dispute and misunderstanding and living a peaceful life. 3, that the first party and the second party entered into this mutual agreement in order to facilitate the filing of criminal petition under so-and-so section IPC before the Honorable High Court Itanagar Permanent Bench for quashing of the FIR dated 30/11/2016, which is registered as so-and-so under WPC, registered under section 498A and 323 of IPC. Your lordship, the FIR is the reason for this FIR is at that point of time, the petitioner number 1 and 2 were having matrimonial problems among themselves. So the petition number 1 is the wife to teach a lesson to the husband. He lodged an FIR in the WPC, and such accordingly the IOS the officer has registered the sections, and accordingly subsequently another case has been charged with treason.
Okay, yes.
Lordship, this is matrimonial issue, lordship, and I have gone to the record also, where does the lordship, this victim, the other side, lordship, the wife have appeared before the court, lordship, and herself, lordship, apprised the court that settlement, we have gone for the settlement, and it is for the quashing, lordship. Then I think it's amicable, they have want to settle, lordship, then it can be quashed, lordship.
The petition will be allowed.
Much obliged.
Like,
How are you?
Thank you.